This is our group member from group 12.
Situation. Mr. J, the instructor, is talking to Farhana, Atikah and Atikah Najwa in his classroom about the general rule that contracts made by minor are void.
Hello guys, good morning. We are going to be discussing a very significant subject today. The exception to the general law that status contract made by minor are null and invalid. The fundamental of who is legally qualified to enter into contract will also be covered.
Mr. J, I always been interested in the law governing contract involving children. Could you provide a true explanation of the legal foundation for the general prohibition against children entering into contracts? Furthermore, what particular or historical factors have shaped this particular area of contract law?
What a great question, Farhana! Let's first review the legal definition of capacity to contract.
All agreements constitute contract if they are made with the free agent of persons who are legally able to enter into contract, as stated in Section 10 of the Contract Act. The idea behind this is to make sure that everyone is aware of the term and is in agreement with them, which call for a certain degree of maturity and mental capacity. The protection is in place because he has historically been believed that mentor lack the maturity and understanding need to enter into legally binding commitment, who is now seen as complete. As person is complete to enter into a contract under Sections 11 if they meet cer- certain legal requirements of sound mind and are not prohibited from entering into contract by any other law.
Mr. J, could you give us a precise definition of a mirror when we discuss them in relation to contract law? For instance, what is the legal definition of a mirror? And are there any age or circumstance requirements that must be met before a person is considered an adult under the law? Are there any variations in this term owing to other legal systems or categories of agreement, as well to contract law?
A individual who has not attained the age of majority is known as a minor. The age of majority under common law is normally fixed at 21 for the majority of purpose. On the other hand, the Acts of Majority Act 1917, Section 2, stipulates that the age of majority in Malaysia is 18. This implies that everyone under the age of 18 is treated as a minor in Malaysia. This relevant status and context can affect the age of majority. For example, you can join the trade union at the age of 16, but you have to be 21 to vote the state and parliamentary election. This difference quality that people only seen as equal when mandatory is essential.
Greetings, Mr. J. I am aware that contracts signed by children are usually null and void, but could you elaborate on why this is the case? What cultural factors and underlying legal precepts give rise to this broad rule? Could you also provide a particular case study that demonstrates this idea in action?
Since kids lack experience and maturity, and the law seeks to protect them from exploitation and unfair agreements, all contracts entered into by minors are generally void. This rule is predicated on the knowledge that minors are not quite competent to understand what a contract entails. Tan Hee Juan versus the Bond Kick is a significant case that serves as an example of this idea. In this instance, the plaintiff, a minor, execute land transfers in the defendant advantage. These transfers were registered and witnessed, but the plaintiff was a minor, so the transaction was void. So the court set them aside. This case serves as a reminder of the legal protections afforded to minors in contractual arrangements.
Mr. J, it appears that one important area in which children can lawfully join into agreement in marriage contracts. Could you elaborate on how this exception operates, specifically in relation to culture contexts? Exists any particular court ruling or precedent that demonstrate how these exceptions are handled in court and the criteria the court takes into account in these circumstances?
Of course, Farhana, matrimonial agreements do actually constitute a noteworthy exception. Certain legal systems and cultures, like Malaysia's, acknowledge that adolescents can sign marriage contracts, particularly when those arrangements entail parental supervision and cultural costume. Ajitswari and Anur versus Balakrishnan and Orbs, 1958, is a well-known case. Nonetheless, the court maintained the arrangement, acknowledging the parents' participation and the cultural costume. To determine whether a contract is in the best interest of the minor, the court takes into account various aspects, including the cultural backdrop, the parental role, and the intention behind the agreement.
Greeting Mr. J. The idea of necessity intrigues me greatly. Could you provide us a detailed description of what the law considers to be necessity? In what way does the law protect kids from being unjustly forced into contract and guarantee that they get what they need? There are many particular court rulings or legal clauses that also show how necessity are handled in contract law.
Excellent query, Atika. Essential goods and services that are appropriate for the minor's stage of life and guarantee the satisfaction of their basic needs are known as necessities. If a minor obtains necessities, the provider is entitled to reimbursement from the minor's property under Section 69 of the Contract Act. Food, clothing, shelter, healthcare, and education are examples of necessities. For example, a minor may be deemed to require a laptop for educational purpose. To decide whether the item is required, the court considers the minor's genuine needs as well as their current situation in life. Crucially, the minor's property is used to recompense them rather than their being held personally accountable. This clause makes sure that children are not unduly bound by contract and can still access necessary products and services. The law offers a mechanism for providers to be appropriately compensated because it acknowledges that minors require these necessities for a healthy life and development.
Could you further explain, Mr. J, how the definition of necessary change based on the unique circumstances of each minor? For example, how do the courts decide what qualifies as a necessity for various minors, and are there any significant instance that she right on this decision?
In fact, the definition of necessities changes depending on the particular situation of the child, the minor's true needs, the type of good or services provided, and their social standing are all taken into consideration by the court. For instance, clothing might be seen necessary, but extra clothing might be viewed as a luxury if the minor already has a sufficient wardrobe. The minor's particular circumstances at the time of the transaction determine the test of necessities. Chapel and Company Limited versus Nestle Company Limited is a noteworthy case that emphasizes the significance of contact in contractual problems while being mostly about consideration. Here, the idea can be used to demonstrate how, based on each minor's unique needs and circumstances, what is required for one may not be for another.
Mr. J, could you please clarify which legislative rules specifically permit the validity of scholarship agreements involving minors? What are the benefits of this agreement for minors? And are there any requirements or restrictions that should be taken into account? Could you also provide an example of how these agreements are put to use?
One significant exception to the general law that contracts made by minors are void is found in scholarship agreements. Section 4 states that the fact the scholar is a minor does not render these agreements void. Awards, bursaries, loans, sponsorships, and appointments to study programs fall under this category. This exception is justified by the desire to aid minors in their growth and education. For example, a kid who receives a scholarship to attend a prominent university will have the agreement upheld so they can get the money they need for living expenses, books, and tuition. The original agreement is still in effect even if the minor does not follow particular requirements, such keeping a certain GPA. This clause guarantees minors access to educational opportunities that they might not otherwise be able to take advantage of.
Mr. J, another area when children can sign contract in insurance. Could you elaborate on legislators' requirement that permit children to enter into insurance contracts, the advantage of doing so, and any safeguard put in place to guarantee equity? Are there any particular instances or situations that emphasize how crucial these contracts are for minors?
According to the Insurance Act, minors over the age of 10 are able to sign insurance contracts. This exception is predicated on the idea that having insurance coverage for oneself or one's belongings is in the best interest of the child. A minor who owns a pricey musical instrument, for instance, might purchase insurance to protect it from loss or theft. By requiring parental consent in certain situations and making sure the conditions are transparent and easy to comprehend, the law makes sure these contracts are equitable and in the best interest of the child. This safeguard guarantees that kids have the required coverage for unforeseen circumstances and helps avoid exploitation.
What occurs, Mr. J, if a minor falsely states their age in order to sign a contract? In what ways does the law address these circumstances, and are there any noteworthy instances that shed light on how the courts manage juveniles who decides?
A juvenile may still claim offensive to escape a contract if they deceive someone about their age and coerce them into signing. This recognizes the immaturity and lack of knowledge of minors, protecting them. Mohammed Shadul Arifin versus Yo Oika is a significant case in which the court decided that no action could be brought against the minor, even if their deception was fraudulent. This decision emphasized the legal precept that minors ought to be shielded from harm, even if they falsely claim to be older, as they lack the mental capacity to fully comprehend the ramification of their choices.
Mr. J, what legal options are available when a contract involving a journal is found to be void but one party has already fulfilled their end of the agreement? In this situation, how does the law ensure justice and fairness? Are there any noteworthy case or legal precept that provide an example of this process?
Farhana, that is a really important question. In the event that a contract involving a minor is declared void, the law often aims to put the parties back in the same position as when the contract was made. We refer to this idea as reparation. Returning any goods or funds that were exchanged as part of the agreement is the aim. For example, in the event that a minor buys a car and the contract is later cancelled, the minor would return the vehicle and the seller would refund the money. Or the other hand, the court may grant the right amount of money if the car is lost or destroyed. By safeguarding minors against exploitation and taking the interests of the other party into account, the law ensures fairness.
Could you perhaps clarify on pupil of sound mind ability to contract Mr. J? What are the consequences if someone enters into a contract while momentary or permanently incapable of making decisions for themselves? And how does the law assess someone's state of mind?
Excellent query, excellent query, Atika. According to the law, a person must be of sound mind in order to be competent to enter into a contract and be able to decide what is in their best interest by reason. A person who is able to comprehend a contract when it is made and make a reasonable assessment of its consequences is considered to be of sound mind. According to Section 2 of the Contract Act, when someone has a mental illness, whether it be chronic or episodic, they are unable to contract during those times. For instance, a, for instance, a person suffering from a mental illness could be able to make a legitimate contract when they are not afflicted by their illness, but they cannot do so when they are. A person who is generally sound mentally but sometimes not cannot enter into a contract while they are not. A contract may be deemed void if it is made with someone who is mentally ill and lacks capacity.
What about the certainty of contracts, Mr. J? How does the law make sure that a contract's terms are precise and unambiguous? Could you give an instance of a contract that was declared void?
Contract enforceability depends on certainties. The language must be precise and not ambiguous. According to Section 3 of the Contract Act 1950, Contract with ambiguous terms are null and void. As an illustration, consider the agreement between the parties in Karupan Chetty versus Swatian to lease real estate for 35 ringgit per month for as long as he likes. The lease period was unclear and not defined, so the court declared the contract unenforceable. The underlying idea here is that for a contract to be enforceable, both parties must be fully aware of their rights and responsibilities.
We have covered a lot of specific example and concept today, Mr. J. Could you list the primary exception to the rule that contract made by minor are void and describe how this exception work to strike a compromise between the need to protect children and requirement to let them to enter into certain kind of agreements?
Yes, Farhana, the primary exclusions from the general rule that contract made by minors are null and void include insurance contract, marriage contract, and contract for necessities. These exclusions are meant to safeguard minors by enabling them to sign contracts that are advantageous and essential to their growth and well-being. Matrimonial contracts take into account costume and family dynamics, guaranteeing that minors are not unjustly punished for decisions made in their best interest. Contracts for necessities shield minors fundamental requirements by ensuring they can purchase necessary goods and services without facing personal liability. Scholarship agreements provide that minors to receive financial help without the arrangement being void because of their age, which promotes education. Adolescents who understand the value of coverage in case of unanticipated events can safeguard themselves and their belongings by signing insurance contract. Every exception strikes a compromise between the need to keep children safe from exploitation and enabling them to participate in advantageous contract.
Mr. J, are there any other significant factors or legal precepts pertaining to the ability to contract that we shall be aware of, especially with regards to safeguarding children and pupils with mental illnesses?
Indeed, Atika, it is critical to realize that the law protects group of people, including kids and people with mental illness, who might not completely comprehend the consequences of their conduct. The concept of capacity to contract guarantee that parties entering into agreements are able to fully understand and approve of the conditions. The legalization shields children from unjust agreements while making allowance for advantageous transactions. The law guarantees that contracts for people with mental disabilities are only enforceable when they are signed by people who are mentally well. The overall goal of this guideline is to establish a reasonable and equitable legal system that strikes a balance between protection and the capacity to enter into advantageous and required agreements.
I am grateful, Mr. J. This has been a really educational conversation. It is evident that contract law is intended to safeguard weaker parties while still permitting them to enter into some advantage our agreements.
You are very welcome, Atikah Najwa. It is essential for anyone studying or practicing law to comprehend these ideas. Recall that fairness and protection are balanced by the law to guarantee that each party is treated fairly. That brings an end to today's lecture. Everyone, great question.